Number 40, people of the state of New York versus Credit Suisse Securities. Good afternoon, Counsel.
Good afternoon, Your Honors. My name is Richard Clary from Cravath, Moore, and I represent the Credit Suisse defendant appellants. And may I respectfully request 2 minutes for rebuttal?
You may have 2 minutes, sir.
Let me begin with very clearly what it is we want. We believe the opinions below should be reversed and that the complaint in its entirety should be dismissed as time-barred under CPLR 214-2. There are only 2 counts.
Counsel, do you agree that if the complaint on its face is enough to make a claim for either common law fraud or what they're calling equitable fraud, that the decisions not to dismiss are correct?
No, Your Honor, I don't agree, because what they have pled are 2 very specific causes of action that are both statutory in nature and which only require limited proof that would not, in fact, prove common law fraud or equitable fraud.
Okay, so then you tell me, what in your opinion, as you read the case law and our history, are the quote-unquote elements of equitable fraud?
The elements of equitable fraud, Your Honor, are there needs to be reliance, there needs to be injury to the victim, so reliance by the investor in this case, injury to the investor in this case, a material misrepresentation at the fraud level, not at the tendency to deceive level that applies for the Martin Act and the executive law. And since there's no scienter requirement for equitable fraud, it has been replaced by a requirement that there be some special relationship or other basis for equity to be invoked. And that prong is important.
What's the decisional law basis for this summary of the elements? What case can I go look at that tells me those are the elements of equitable fraud?
Well, I think, for instance, this court's Connaughton decision from last year discussed fraud and said whether it's at law or in equity, there has to be reliance that produced injury, and it has to be adequately alleged in the complaint. And so this court affirmed the dismissal, in that case a fraudulent inducement claim, where those elements were found to be missing.
So would you see the types of fraud, that legal fraud that we can find falling along a continuum from common law fraud, which includes scienter and reliance, to the Martin Act and the executive law, which just included material misrepresentation, with equitable fraud being in the middle, including reliance, but not any form of severe falsity or scienter?
Yes, I would put equitable fraud almost right next to common law fraud. I actually find it easier, Your Honor, to think of it as an archery target. And you have the bullseye in the center, and the bullseye is common law fraud, and maybe slightly around it is equitable fraud, with all of the elements that have to be proven to win for that.
I like the bullseye analogy. It's good.
And everything else is the Martin Act and Executive Law 6312, and the Attorney General can win as long as they prove anything anywhere on the target. And in this case, they affirmatively told us and the lower courts that they were not intending to prove reliance and not intending to prove scienter.
So we're in the outer ring.
So we're in the outer ring, and to be in the outer ring, in order to establish liability, all they have to prove is the tendency to deceive standard and materiality.
Well, but I just want to be clear. So if that's true, you're basically conducting a case-by-case analysis of this particular complaint. You're not suggesting, are you, that any time the Attorney General is invoking the Martin Act, that if that particular complaint happens to have the elements of common law fraud or equitable fraud in addition to a Martin Act and executive law claim, you're not suggesting that those would also require a 3-year statute of limitations?
To be clear, Your Honor, I think the 3-year statute of limitations under 214.2 applies to any Martin Act claim where the Attorney General seeks to impose liability based on the Martin Act. So, for instance, if there was a complaint that both alleged a Martin Act violation and a common law fraud violation, 2 separate counts, the 3 years would still apply to the Martin Act, because to win it, all they have to prove are the stripped-down limits.
So we have to actually look at how they build it in the complaint, as opposed to what the facts are that they've alleged.
Yes, Your Honor, the trial court would turn to the portion of the complaint that says, and here are our counts. And count 1, we sue under the Martin Act.
Paragraph 73 through 76.
Right, so they're suing under the Martin Act, and then they're suing under Executive Law 6312, where they recite just the words of Executive Law 6312 and then add in parentheses, including inter alia multiple violations of the Martin Act. So which we interpret as meaning that it's a Martin Act claim, and the executive law claim is piggybacking on the Martin Act claim, and therefore they both attract the same statute of
Yeah,
limitations.
but we have liberal pleading standards, and so as long as you can look at that complaint anywhere and find, let's stay with your argument, allegations of common law fraud, the complaint survives and they can continue for that common law fraud. Let's say we agreed with you on the statute of limitations issue, correct?
Where I would disagree, Your Honor, is statute of limitations has to be decided normally at the beginning of the case. It's raised on a motion to dismiss to see whether or not the case should proceed. So I think the question is not, and the way the court analyzed it in Gaydon 2, is not based on, can I find allegations that will add up to something other than the counts that are actually pleaded. In Gaydon 2 and in motor vehicles before that, a decade before.
But
So
your,
you do a claim
your
versus
own
a claim.
bullseye analogy is that common law fraud is the center of the larger, right, bullseye?
Yes, Your Honor.
So as
but-
long as those elements are properly alleged and there's a factual basis for it, and you have to assume the facts as presented are true for purposes of the motion to dismiss, you move on. I understand your point about the statute of limitations, but if you satisfy those elements, they can then move on. They may not be able to prove it, of course. That's a different story, because that's a different standard once we move past the motion to dismiss.
Your Honor, where I disagree with you respectfully is, if they're going to allege common law fraud, they have to bring a common law fraud claim. If they want to allege an executive law 6312 claim premised
I
on...
mean, if they had put the wrong title at the top of their cause of action, their claim, but everything in it, it contained every element that you would agree is the element required for common law fraud, you'd still have to dismiss that complaint?
Well, Your Honor, that isn't the instance we have here. And I don't think the Attorney General would ever make that simple a mistake in a complaint. I think they're very clear. They were very clear in what they were alleging, and they were very clear in the trial court on what they intended to prove and what they didn't intend to prove. And they said, we're not proving scienter and we're not proving reliance. And they have steadfastly refused to give us any discovery.
That's based on that letter response, is that correct?
They also said it during the oral argument of the motion to dismiss, Your Honor, which is in the record as well. They have consistently throughout this case said, we're not going to prove reliance, and we're not going to prove scienter, and we're not going to give you any discovery on those subjects. So they have never been pretending that this was a common law fraud claim or an equitable fraud claim. It has always clearly been a statutory claim.
Thank you, counsel.
Thank you.
Counsel?
Please the court, Barbara Underwood for the state. The complaint in this case alleges misrepresentation to investors of material facts relating to the sale of securities. That is a classic, long-recognized wrong for which equitable relief was available before any relevant statute was enacted. Bloomquist is one such case. Hammond is another. We've cited these cases.
Ms. Underwood, can I stop you for just one second? Your analysis, the argument I think you're presenting is the same argument that the AD said, basically that the act's targeted wrongs that existed before the statutes were enacted. And I guess my problem here is that the question here isn't the wrongs, but really the question for statute of limitation purposes is what elements have to be proven. So
No,
let
I
me
don't
just,
think
let me
that's-
just, let me
I don't
just finish
think-
my
yes, of
thought.
course.
All right, and then I'd like you to respond. And so the elements that have to be proven are the 5 elements of common law fraud, it's as opposed to the lesser elements for both equitable and Martin Act situations. How do you get around the fact that you're not proving scienter or reliance in either circumstance, and the 3-year statute then doesn't apply?
Okay, I have
Go ahead.
several things to say about it. One, I think this court has not said there has to be a pre-existing cause of action. It said there has to be a pre-existing wrong.
Wrong or a remedy?
Wrong. What the court said in Cortell was that as long as the wrong is the same, new remedies and new standing don't change, don't call into play 214.2.
Well, but we've also said it's not enough that it's akin to something else,
That's right.
right?
That's
And
right.
that at the very least, whether the elements of the cause of action are the same is a factor to be considered.
I think that's right.
Right.
Maybe I should go
So-
right to the scienter and reliance points, which is the absence of scienter certainly doesn't mean these statutes address a new form of wrongful conduct, because courts were providing relief in the form of rescission, for one, and other kinds of...
You're not seeking rescission.
No, we're
here.
not. That's a remedy point. But the wrong, it was wrongful to make a material representation with respect
But
to...
you couldn't bring a claim for the relief you're seeking under the common law.
I think the point that we're discussing is whether a different remedy brings, whether when a statute provides for a different remedy, it is creating something new and statutory or not. And what this court has said, and there's good reason for it, which I'll get to if I may, but this court has said new remedies don't make an old wrong new. They just provide new remedies, new standing, new enforcement mechanisms. So rescission and other equitable remedies established long ago that this conduct without scienter was wrongful. And what we have in these statutes is new Attorney General authority to address those old wrongs.
So let me just
Now,
understand for
reliance is a
myself.
separate question, and I'd like to turn to
Yes,
that.
let me just ask this. So then, what is the essence, assuming we agree with you, what is the essence of the wrong? Is it just misrepresentation that's material, or is there something else?
It's a misrepresentation that is material, a misrepresentation that is material in connection with, here it's in connection with the sale of securities, which itself was an old pre-existing wrong.
Can you cite any state cases in which that held that reliance is not an element of equitable fraud?
Okay, this is reliance now.
I'm talking about
We're talking about
reliance.
scienter, and now on reliance, again, I will say it's not a question of the elements of the action, it's a question of wrongfulness. And my submission on that is that reliance is not...
But wouldn't that, if your argument is correct, right, then wouldn't we have said that as to the Deceptive Act and Practices Act under general business law?
No, and this is the
Why?
point that I think has been confused in some of the briefing here. The history of the Deceptive Practices Act is that it was enacted in order to reach beyond pre-existing wrongs, so that fraud under the Martin Act was said in Federated Radio to be very broad, but to address all pre-existing wrongs. Fraud under 63...
And others.
No, I think just pre-existing wrongs. And fraud under 6312 was said to be the same
Why
as...
would it be necessary to address pre-existing wrongs if it was exactly the same as the common law?
To give the Attorney General preventive enforcement power. And that is also going to be my answer to this point about reliance. The innovation of the Martin Act wasn't the scope of conduct that was prohibited. It was to authorize the Attorney General to act preventively, to prevent fraudulent practices from causing harm. Initially, it was only about, it only authorized injunctive relief, appointing a receiver, taking steps to prevent these harms from happening, because the traditional individual private actions to redress harm that had already occurred wasn't sufficient. That was the innovation of the Martin Act. And prevention, of course, by its very nature, doesn't wait for reliance. The whole point of this was for the Attorney General to come in and stop the frauds from happening, prevent them from happening, enjoin them, bar people who engaged in them from dealing in securities. There's a whole array of preventive remedies. Those aren't the only remedies, but that's the origin of this statute, and they were initially the express remedies of this statute. So the Martin Act, and then 6312, the innovation of that was
But
simply
based on misrepresentations that had been made.
based
and
on
material.
misrepresentations that have. I suspect if somebody announced they were going to make misrepresentations, there could be an injunction to stop that. But the ordinary course would be misrepresentations that had been made, but that might not yet have been relied on, that might not yet have caused harm, and the Attorney General was given the authority to come in and stop it. And that is why...
Maybe I'm misunderstanding, but it seems that we're back to the elements of common law fraud, equitable fraud, and the Martin Act. And common law fraud has the toughest standard. The Martin Law Act has the lowest standard. And if I understand correctly, what you're saying is that the Martin Act doesn't require reliance. I would agree with that. But equitable fraud does.
Yes,
So in that situation, is it at 6 or 3? It seems the law is at 6.
It's
For equitable fraud and 3 for the Martin Act.
No,
So
because the Martin-
let me finish my
Yes,
thought.
of course.
If that being the case, Ms. Underwood, then you would have to have pled reliance in an equitable fraud form. That's my thought, anyway. And you go ahead and respond.
That is essentially the Credit Suisse's position. And what I'm trying to explain is that the wrong that all these statutes are about, 349 I put to one side. The wrong of equitable fraud, the wrong addressed by the Martin Act, and the wrong addressed by the fraud component of 6312. We have to put aside illegality, because that could come from old or new statute or not statute. But the fraud component of 6312 is the same language. They took exactly the same language that was in the Martin Act and put it in 6312. So those two statutes stand together to address the same fraud. And then 349 is the only one that reached additional conduct that this court correctly observed in Gaydon was conduct that wouldn't rise to the level of fraud.
Let's assume that 6312 and the Martin Act are the same for purposes of what has to be proven. But 6312 can be based on other things besides the Martin Act, right?
Yes, fraud, and it was here. This is
are you saying that when it comes to 6312, we have to look at the individual allegations in the complaint, so that 6312 may sometimes be subject to a 6-year statute of limitations and other times to perhaps a 3-year statute of limitations?
Well, as to illegality, that is certainly true, because if a 6312 is persistent fraud or illegality, if the illegality comes from a statute, then we're talking, and is new in the statute, then a 6312 based on a statute, it comes from whatever the period is under the statute.
I don't know if this is possible, but if it is, what if it was based on general business law?
The Martin Act, you mean?
No, the 6312. There was a 6312 cause of action. Could you do that?
I'm sorry, a 6312 action based on
a
349?
violation? Yeah. Yeah, is that
If
possible?
it was based on 349, then it would take the statute of limitations from
Okay.
349.
So it depends on how it's pled, is what you're saying.
At that level, at the level of is it fraud or is it illegality? If it's fraud, the word fraud in the in 6312 means the same thing as the word fraud in the Martin Act. I will say that there is an open question what you do if a statute, and you could say this about the Martin Act too, if it covers some old fraud and some new fraud. That's not our submission. Our submission is that all fraud covered by the Martin Act in 6312 was old fraud, not redressable in the way it is here, but it was pre-existing harm, pre-existing fraud, and therefore all fraud cases under 6312 should get the 6-year statute.
But in 6312, you have
And
to
the
show that it's persistent
Yes,
fraud.
that is the
That's the
distinction.
difference you're saying between these two, when it comes to fraud.
Yes, another difference is that 6312 isn't secure, it doesn't have to be in securities. It extended the general remedial scheme of the Martin Act to the marketplace outside of securities fraud. It found that to be a successful or a desirable mechanism, and it extended that mechanism to the marketplace outside of securities. Here, of course, we are talking about securities. I think there's an important thing to understand. I don't know if you want me to stop because my time is running here.
You may have a moment or two.
To understand 214.2, to understand the statute, the category liability created by statute, it has consistently been given a narrow interpretation by this court, applying only to newly created rules of conduct, and there's a good reason, and that's because it's a default rule for an extremely wide variety of possible claims, and so it's not really tailored well to any one of them and should be resorted to only when there's really no alternative. It was certainly not enacted in reference to the Martin Act or 6312, as Credit Suisse has suggested. To the extent the drafters were thinking of any particular kinds of claims, the legislative history shows what they were thinking of. In 1848, in the enactment of the Field Code, they gave 6 years to this category, liability founded on a statute, and they explained in the commissioner's report that's in our main brief addendum at 20 and 21, they explained that most liability created by statute is rather like contract. It suits against corporate stockholders and officers, and they should get the same limitations as contract. And then in 1962, when the CPLR was enacted, they made the drafters made the period for liability created by statute 3 years, with the advisory committee report, which is at 129 of our addendum, saying actually now most claims raised by statute are rather like torts, are rather like negligence, and they were looking at workplace safety rules and provisions of that sort that were where the alternative was going to be the 3 years for negligence. So there was kind of a rough justice idea that most statutory claims are of one kind or of the other, but that in any case it was a very rough justice. It wasn't going to actually be right for every claim. And I think that's part of why it makes sense and part of why the court's jurisprudence has emerged to apply the 214.2 statutory category narrowly, essentially only when you have to. And when there is a pre-existing wrong, you use the statute of limitations for that pre-existing wrong.
Thank you, counsel. Mr. Clary?
Thank you, Your Honor. Let me start by saying I understand why my opponent wants to put 349 over to the side, but it can't. 349, as this court has recognized and many of the lower courts have recognized, and as they recognized in their amicus brief in Gaydon 2, was modeled on the slimmed-down liability of the Martin Act, which, and then Executive Law 6312 was modeled on the Martin Act. So it's the Martin Act as tendency to deceive.
So then what do we do with the broad definition of fraud, though, that's in the Martin, in Federated Radio, that was the very first case, interpreting the Martin Act?
Yes, Your Honor, and that's entirely consistent with my argument. It is, the Martin Act is as broad as the mind can imagine And that's exactly why liability under the Martin Act is broader than pre-existing liabilities under these more rigorous doctrines of the common law fraud or equitable fraud. It's exactly because Federated Radio said the Martin Act is the best investor statute New York is ever going to have, and frankly, the country is ever going to have.
So to rule your way, what do we do with the Cortel?
Yes, Your Honor. On Cortel, which is a 6312 claim, this court recognized that 6312 has two types of liability. It actually uses that terminology. It says it can cover existing liabilities, and it can cover new types of liabilities. And then it has a compare with citation to lower court cases, and the two representing new liability are two cases comparing Executive Law 6312 and saying that's like the Martin Act. So that's the new type of liability in the Cortel opinion, whereas the compare with is another case. So those two cases are People against Beavis and People against Interstate Tractor. And then there is a cite to another case, which is a holding of an Executive Law 6312 liability, where it recites that they have proven every single element of common law fraud, and that's the old type. And then this court said,
But if we have these cases that the Solicitor General has already referred to, where you don't need the scienter, you don't need the reliance, but it's recognizing fraud, how is it that we can hold in your favor?
because fraud at the level of the Martin Act is a different creature, a much broader creature than common law fraud or equitable fraud. It covers a multitude of sins. As counsel just said, there's no requirement of reliance. That's obviously very different from any type of liability for fraud that existed previously. They've also eliminated scienter, which was required for common law. They say it eliminates the need to prove any kind of injury to the consumers.
Are you saying then that the cases referred to by the Solicitor General do not say what she represents? They say, which is that you don't need those elements nevertheless to show fraud?
No, I'm saying they do say what she says, which is you don't need those elements to prove Martin Act fraud. And you don't need those elements to prove Executive Law 6312 fraud unless it is piggybacking on an honest-to-goodness common law fraud claim, which was what the court had in Cortel. You actually have the Cortel complaint in the addendum to the reply to the amicus brief in this case, and you will see that it recites count by count.
So those cases are not dealing with fraud and equitable fraud and equitable remedies. Is that what you mean?
Yes. Equitable fraud still requires reliance, still requires injury to the victim from that reliance. And they're saying, Martin Act and Executive Law 6312, we can impose liability on you without ever proving those or offering any evidence in discovery about those. And that's why it is a liability. The statute, CPLR 214.2, talks about liabilities created by statute. It doesn't talk about wrongs. It doesn't talk about conduct. It talks about liability. And this court in Gaydon 2 showed how to do that analysis by looking at the claim, looking at the elements of the claim, and then looking at whatever was the claim pre-existing at either common law or equity, see what the difference is.
But we've also said that if the statute merely provides for standing, that is someone that, or an entity that would not otherwise be able to bring an action, they're now allowed to bring the action. And that you can get remedies that someone else might not have been able to get.
But it clearly does more than just create standing, Your Honor. And it clearly does more than just create remedies. It imposes a level of liability on the basis of a level of conduct that would never prove either common law fraud or equitable fraud.
Thank you, counsel.